Court is now in session. To most people, those are not great words to hear. They usually foretell hours and hours of endless drudgery and violent emotions. But to a select few, those words are the ring of a bell, the signal of the beginning of a vicious and relentless face-off in which only one party can emerge victorious. Hi everybody, my name is John Wu, and today I'm here to talk to you all about LinkedKey's new mock trial program. It's a very exciting program. I'm really happy that all of you guys took your time to come out here and join us today. And yeah, I hope you guys will enjoy the presentation. If you do have any questions, I will try to anticipate some of them and be answering them throughout this presentation, but we will have a session afterwards, so please save it for that. Yeah, so a little bit about myself. My name is John, as I mentioned before. I am actually a full-time entrepreneur. I'm the director of a company called Codified Legal Publishing. We essentially sell legal information to law firms. But aside from that, as a sort of a side hustle, you might call it, I'm actually a law student at Osgoode Hall right now. I am on the extended time part-time program, so I do about one or two classes a semester. And I've been doing that for the last 4 or so years. So yeah, I have a rough idea on what the legal industry looks like. And yes, I'm also doing a joint MBA at the Schulich School of Business, but it's not quite as relevant to today's talk. So a little bit about my past experience. Why am I actually even qualified to be here? So I do represent Osgoode as a member of its competitive moot team. I've competed multiple times on the international circuit. Last spring, I was fortunate enough to qualify for the Oxford International Moot. So, you know, the school sent me off to England. Had a really amazing time there. It was, yeah, definitely one of the highlights of my law school experience, and made a lot of close friends who I know I'm going to be in touch with for a long time into the future. And yeah, as a part of the competitive mooting program, they actually do assign you law firms to train you in litigation. So yeah, I was fortunate enough to get assigned Castles, Brock, and Blackwell. They're a very well-known litigation firm. They do a lot of intellectual property disputes, and recently they're become a very big player in the whole cannabis space. Yeah, so do have a little bit of formal experience, and yeah, I have presented before Canadian Supreme Court justices on 3 separate occasions. Yeah, it's a fun little fact. I mean, not a lot of students have that opportunity, so I really am kind of grateful for it. Needless to say, it was absolutely nerve-wracking sitting before people with such a illustrious history of giving out judgments, but managed to squeak through it. And yeah, as far as my actual outside of law school, my experiences go, as a professional business person, I present all the time. It's my job to go off to various companies and give presentations, kind of like this. Everywhere I go, I'm presenting. This is me at the Ontario Access to Justice Challenge, which was held 2 years ago with the Attorney General at the time. So yeah, in terms of general presentation skills outside of the whole legal realm, I have gotten quite a lot of practice. And I do think presentation is one of those skills where you can pretty much carry it from one thing to another and take it with you. So what actually is mock trial? It's pretty much exactly what you would imagine it to be. It's essentially like a simulated version of an actual court case. And the idea behind it is it's meant to simulate a court case as close as possible without introducing some of the more problematic elements. All the sort of paperwork and prep that takes years and years before people hit the courthouse, all that is gone. So they focus on the essentials. What does it actually take to go up there and create a compelling case? What does it take to sell someone on your story? So yes, students play the part of lawyers and occasionally witnesses. And they argue before a panel of jurors and judges. So it really depends on where you're located. In Canada, generally speaking, it's a more judge-based system. You'll be arguing before a panel of judges. In the United States, it'll be a panel of jurors. But for all intents and purposes, like, it's essentially the same thing. The jurors are acting as judges, the judges are acting as jurors. There are some distinctions that have to be made in terms of how you address them. But at the end of the day, you have a panel of people. Your job is to win them over, prove yourself to be right, and prove the other side to be wrong. Yeah, just give everyone a moment. Yeah. Yeah, so question I'm sure all of you guys have, if you guys are familiar with LinkedKey, is how is this actually different from debating? There are a lot of similarities, but there are also quite a lot of differences. I was a very avid debater all through high school. I went to Iroquois. I mean, was very involved in the debate program there. So heading to law school, I thought, I could transfer over some of that experience. Yeah, absolutely not the case. I went into my first moot at the time, prepared for a debate, and I did absolutely terribly. It's a very different sort of style of presentation, whereas debate is generally a bit more flexible in terms of how you come up with your creative arguments. Mooting, you're arguing about the law. You're arguing about the law. Even when you're arguing about things that aren't related to the law, you have to place it within the context of the law. How does this evidence fall under the legal system? How does this narrative relate to the actual burden of proof that you're trying to establish? It's a lot more formalistic of a process. You gotta have a sense of composure, so to speak. Sort of composure and a sort of formalistic attitude towards it. But it's mixing that with the personal touches. It's mixing the formalistic with the personal. It's keeping it as official as you can, keeping it professional, but at the same time appealing to your audience. It's mixing in those two that makes mock trial truly challenging. So another question you might have is, why haven't I heard of mock trial? Compared to debating, it is definitely not quite as well known in a lot of places. And there are reasons for that. Generally, mock trials are ubiquitous in universities. Pretty much every university you go to will have a mock trial or a moot team. And yeah, every single law school does it. Almost like a religion, like people get super into it. But yeah, there's a number of reasons for why generally it's not done at the high school level. There is a perception that students are not sufficiently advanced to be able to take in the content, to be able to understand the law and to go before someone and argue it convincingly. Frankly, I don't think that is true, but we'll get to that in a second. There's also a general lack of opportunities. There aren't as many mock trial tournaments in Canada as there are in other places. And not a lot of high schools actually have teams. So for students to actually participate, if their school doesn't have a program set up, they would actually have to go on their own to set it up. Which frankly speaking is a lot of work for a student on top of being a competitor. So that's also a significant barrier. And yes, last but not least, the lack of mentorship and coaching. There are quite a lot of debate programs, and because there are all these debate programs, they do have a very robust network of coaches and mentors who are willing to come out and give their time, right? Because the mock trial circuit is not as well established in high schools, and there are less tournaments, as a result, there are just simply less coaches to reach out to help you set it up. All of these are obstacles, which this program is meant to overcome. These are, frankly, things that I think, they're not good reasons for why Canada doesn't have a robust mock trial system. I think we should. I think these are things that can be overcome, and we'll touch upon that later in the presentation. So, just to give a rundown of how mock trials are actually done, it's quite straightforward. So firstly, students will receive a fact pattern. In certain instances, this fact pattern will actually be based off a real court case that was litigated. And then in other cases, it'll be something that is pieced together from other fact patterns. But generally, the idea of this fact pattern is it's meant to reflect some degree of reality. Occasionally there'll be something a little bit outlandish, like a murder that's done in a really funky way, but for the most part they try to actually keep it grounded in a scenario that's real and applicable. After the students receive the fact pattern, which will include not only the facts of the case, but also the evidence, who the key players are, and other case materials, at this point they do case analysis and legal research. So they'll actually start digging through this case. They'll start identifying what are the issues that are at play. What are the laws that are relevant here? And actually read through the case material that's being provided. How does this case compare to other cases that happened before it? From that point on, students will work together to create a list of arguments. They'll practice their oral arguments in order to prepare. And then last but not least, they run through a full mock trial, complete with direct examination, cross-examination, so on and so forth. So, why do mock trial? Like, what's the actual benefit of doing this? You might be asking yourself, I mean, to some level it might seem like make-believe land, right? Why are we arguing about a case that may or may not exist when, frankly speaking, we're not even legal professionals here? Well, it does build a lot of skills, which are very readily transferable into other things. The first one is critical problem solving. There's a lot of very complex relations between the facts of the case, between the law, and then you have to somehow work it together to create a compelling narrative. There's this perception that a lot of the time the law is just the law. It's just there, it's straight cut. In fact, there's a lot of interpretations on how the law can be read. There's a lot of interpretations on how it applies to the facts. And then you add on top of that the number of ways you can interpret a single story. Sure, one person might tell it one way, another person might tell another. There's literally countless different ways to argue a single case. And my experience, I've seen some people pull out some really creative arguments in these sorts of scenarios. So yeah, there is that. The second thing is, professional speaking. It is within a legal context. So if, yourself or your child wants to consider a career in law, I mean, it is great practice. But even if they don't, there is a huge benefit. These are incredibly high stakes and very intense scenarios you're sitting in. You're literally there before an audience, you're being grilled with questions, every single word matters. You're kept to a very strict time. Like, time is very important in these things. You're always keeping track of how much time do I have left? How many more seconds do I have to make the point that I have to make? How do I adjust my strategy on the spot to adjust for how the trial is going, to adjust for how the jury or the judge is reacting to what I'm saying? Being able to make all these sorts of adjustments on the fly is a very challenging thing, which I, frankly speaking, have much to improve on. But yeah, through my experience in mock trial competitions, it's definitely gotten a lot better than it was. Knowledge of the legal system. Now, this is a bit of an odd one. I mean, if you're not planning to go into a career in law, what's the point of actually, learning about the legal system? There's actually a big point. The law literally affects everything around us. The way those lights are set up there, there's some kind of law determining that. The way this business is run, I'm assuming it's a corporation. Yeah, that was set up through the law. The streets, the houses, everything around us, the fire exit even, everything around us is governed by these sets of rules. By gaining some basic understanding of the legal system and the forces that are at play in it, you can actually extend it well beyond just a trial scenario. Being able to actually look up a statute for yourself to figure out a question. Being actually able to keep up with the latest case law, the latest court cases that are coming out, and understanding what impact that will have on greater society. These are things that are very, very relevant outside of the legal profession, especially when we live in a time of such a political turmoil, let's put it that way. And yeah, last but not least, leadership in a very dynamic context. These are collaborative problems at the end of the day. Students are working with each other. And whenever there's teamwork, there is bound to be challenges. People have different ways they want to tackle different issues. To be able to pull together all this takes a great deal of interpersonal ability. You need to be able to understand where other people are coming from, and you need to adjust your own work style in order to accommodate that. Frankly, these can be incredibly high stress situations. I mean, before our tournament, we spent literally 12 hours a day locked in the same room working on our submissions. And yeah, it was stressful. I've been involved in business for a number of years now. I thought I had a fairly strong grasp of, what it's like to work in a team. But when you're working on problems that are intellectually as challenging as this, with so many different ways of solving it, with everyone bringing their own perspectives to the table and their own backgrounds, yeah, it is a real testament to how well you can pull together a team. And then, yeah, last but not least, yeah, strengthen your university applications. This does look great on a uni app, mentioning that you did compete in mock trial. There is something in particular which Jonathan will speak about soon, which will shed a little bit more light on this point. I'm not going to touch upon it too much now, so he can give the full thing. So yeah, the gist of the LinkedKey mock trial program, as it's being launched, is essentially to introduce students to mock trial. We'll start off by introducing students to the legal system, getting them to understand, what the law is, right? Who makes the law? Where does it actually come from? How do people actually determine what the law is, right? And then from that point on, actually understand how to interpret the law. Where did this law come from? Was it drafted by the government, or was it created by a judge, right? And from that point onward, understand, what is the effect of this law? How does this law affect other things, right? Is this actually a law that's relevant to this case? Is this actually a law that's relevant to society? Or is it an example of what we call like bad law? Like laws that are just not laws that nobody follows and no one enforces. And it's just a line on a piece of paper and irrelevant. Being able to identify what are those, right? And then, yeah, we want to engage the students with real cases. Actually hit them with real court cases and have them argue it. Present them with the most ambiguous, the most controversial court cases that have happened in recent years. Get them to take a side. Get them to put themselves in the shoes of the lawyers who are arguing these cases. And then just think about how to best argue it. I think there's a great deal of importance in grounding things in reality when trying to teach. When you keep things in the abstract, when you keep things in the philosophical, it's hard for people to stay engaged. You need to give them a reason for why this really matters. And I think engaging students with real cases is a way to do that. There'll be extensive practice sessions, of course. Lots and lots of practice. I mean, practice is the key to any form of success in anything. And all this is to prepare them eventually for competition in the international sphere. And on that note, I would like to welcome Jonathan to the front to give a talk about his experiences with mock trial.
Yeah, for sure. Thanks, John. So what I want to do is I want to talk really quickly about one tournament in particular, the Empire Mock Trial World Championships, and my experience with my mock trial team at my high school. But before that, I have a really quick story just to add on to what John was talking about when he was emphasizing the importance of being flexible and understanding the legal system. So I'm in grade 12. I have a friend, his name's Evan, and his dad, a couple months back, he got a speeding ticket. Okay, so I'm sure most adults in the room have gotten speeding tickets before. And if they haven't, well, it's where a police stops you for speeding. And there's really two options you can go down, right? You can plead guilty and pay the fine. You might get some sort of deductible, or you can take it to trial and argue it in front of typically it's a judge. So Evan's dad gets a speeding ticket, and his dad, knowing that Evan is pretty good at the law and he wants to be a lawyer, goes to Evan and says, "Hey Evan, do you want to represent me at court?" So my friend Evan says, Absolutely. And there's this one thing that he found within the law. I forget which section it was, but there's this one particular clause which says that the police officer has to. So there's a speed gun, right, which he uses. The officer uses to test, how fast the car is going. There's a particular section under the law that says that I think it's a bylaw that says that the officer needs to reset and test that speed gun every time he takes it out. So every day he takes it out, he needs to reset it and recalibrate it. And it turns out that after Evan filed for disclosure, which is basically obtaining the officer's notes, he found out that that particular day, the officer didn't recalibrate his speed gun. So Evan goes up, he's cross-examining the police officer, so he's asking the police officer questions, and he gets to the question of, "Officer, you didn't recalibrate your speed gun today, did you?" And the officer says, "No, I didn't." And long story short, his dad didn't have to pay I think it was $500 fine that the police officer levied on him. So this is just another example, and I'm not saying that you need to become legal representatives to your parents, but it's an example as to where knowing the law is actually really applicable and helpful in everyday life. So back on topic then, let's talk about the Empire Mock Trial World Championships. So a bit about me really quickly. So I'm Jonathan, I'm in grade 12, I study at the University of Toronto Schools, it's a school downtown. I've been involved in our mock trial program for about the last 4 to 5 years, and I've attended the Empire Mock Trial Championships for the last 3 years consecutively. I came 7th best lawyer out of around 500 plus competitors last year. Unlike John, who's presented in front of a couple of Supreme Court justices, I've presented in front of a couple of Ontario Superior Court justices, so a bit lower on the hierarchy of justices, but I think still pretty cool. I've won the OBA, which is the Ontario Bar Association's Charter Challenge, which is a written submission. So just a couple of things that I've done within the high school mock trial circuit. So let's talk about the actual tournament itself then. So there's 3 competitions yearly. These competitions are typically really close to each other, so you'll have to pick and choose one of these competitions to go to every year. There's 3 of them. So over here we have the Southern Showdown, which is their tournament in Atlanta. Over here we have the Battle by the Bay, which is their tournament in San Francisco. And finally we have their World Championships, which is held in New York City. So there's a bit of a difference in competitiveness between these 3 tournaments. The 2 on the sides are relatively less competitive than the World Championships, obviously, just because these are more of the preliminary tournaments. So what you actually have to do is, obviously, you first have to apply to be even a part of the Empire competitions. They'll typically first assign you to one of these tournaments, so either the Atlanta one or the San Francisco one. I know the first year that UTS went, which is my high school, we went to the San Francisco one just because we didn't have any experience with the US legal system, and we've never participated in one of these Empire tournaments before. Nowadays, so for probably the last 4 years, we've been going to the New York World Championships. The reason for this is because we did really well that year in San Francisco that we went. I think we placed like top 5 teams overall. And what's really impressive about that is that lots of these teams are all from America, and Empire operates under the American legal system. So lots of the law that they are having to grapple with is much more accustomed to their liking than it is to a Canadian liking, which does have a bit of nuances in the differences in law. So these are some of the world's best teams. They come from 7 different countries, and there's around 4,500 students participating in all 3 of these tournaments combined every year. So it's a relatively large tournament, and there's a lot of really good competition. So the one thing that I wanted to just touch on and emphasize really quickly about these tournaments is the level of preparation that goes into a mock trial tournament. I think John touched on this a bit, but I just want to emphasize how important it is, the preparation aspect specifically. So just to give some context, when they release the cases are all are the same for all 3 tournaments, by the way. when they release the cases, they'll send each coach or each student executive a massive PDF. And when I'm talking about a massive PDF, it's around 350 pages of information. Okay, so information relating to the legal statutes that you need to know, witness affidavits, things around pretrial argumentation. So there's a lot of things that they will send you. And what you have to do before you go to the tournament is you have to obviously read all 350 pages incredibly thoroughly, pick out the parts that help your case, and then implement that into some sort of cohesive case where you can tie from the opening statement to the closing statement a comprehensive outline of what you were trying to prove, given the burden of proof that you're given for the particular case. So let me give you an example. A couple of years back, we had a case about this dude. His name was Donald Trump, and he was a presidential candidate, and there was an assassination attempt on his life. And the dude who was, doing the assassination was caught, and he was on trial for attempted murder. And we got the case in around July, August-ish. So around in the summer, and the tournament, the New York tournament is in mid-November. So we had around, a few months to prepare. And it took at least probably 10 hours of work every single week for every single member on the team from the start of school, so early September, until the tournament, which was November, in order for us to have some decent shot in competing. And the reason why this tournament is so competitive is because lots of these US schools aren't just very, know the legal system very well, but they also have a lot of resources at their disposal. So there's some schools that literally have mock courtrooms in their buildings, so in their schools. They'll hire real lawyers, they'll sometimes even hire justices in order to prep their teams. So it's a really, really competitive tournament that does require a lot of preparation. So that's the first thing that I want to emphasize. Is, as John was speaking about, how well mock trial looks on a university application, because I think at the end of the day, all of us do have to apply to university, and that's something that you obviously have to keep in mind. Although I don't think it should be the main thrust of why you want to join mock trial, but it's definitely a secondary incentive that you do have to keep in mind when you're making the decision. So going to any sort of international competition is already very impressive, but going to a competition that is as selective and as competitive as Empire is, I think, something that will put your application over the top and make you stand out over the hundreds and probably thousands of kids in Canada, and if you're applying to international schools in the world, who are applying to the similar sorts of programs that you are. So going to a tournament like Empire, whether it's Atlanta, New York, or San Francisco, will definitely give your application a boost. So that's just my quick little spiel about mock trial. If you have any questions about my personal experiences, feel free to ask me at the end of this presentation. Thanks, guys.
Yeah, thank you, Jonathan, for sharing your experience. That was great to hear, and love the stories. yeah, it's awesome. I would like to share one of my own in terms of that stuff. Adding on to what Jonathan was saying, the benefit isn't just in terms of university applications. So in law school, we do something called OCIs. It's sort of like the law school version of a university application. It's a 2-week period, and this 2 weeks is mandated by law. It's a 2-week period where law firms are allowed to recruit students, and they're not allowed to touch students outside of that very short window of time due to fair hiring practices and so on and so forth. And essentially, students sit down with these lawyers for what can only be described as a speed dating session. You rotate from lawyer to lawyer, spending 15-20 minutes just chatting with them about whatever. They don't question you about the law or anything. It's assumed that you know the law just by being there. And it's assumed that you're qualified for the jobs, on the basis of your application. It's more an opportunity for them just to find out a little bit about you as an individual. Who are you as a person? My colleagues who have gone through the OCIs, who did the moot with me, pretty much all their interviews were pretty much them just talking about their experience doing mooting, and their experience going off to England and competing, and their experience meeting all the people there and seeing all the sites and partying with people from a whole bunch of different countries and all the stuff that they learned. And they were saying this because all these lawyers had gone through it themselves. All these lawyers had done that exact same thing back when they were in law school. And they went through that exact same furious grind of work. The competition, and then the sigh of relief as you walk out of that courtroom after you finish presenting. So yeah, in addition to whatever benefits it could have on university applications in the short term, this is the sort of thing which is hugely impactful in your development as an individual. And you do carry it with you as you go forward into your career. I myself, I have no interest in practicing law. I'm a business person. I like helping lawyers with their work. I like to, play more of a support role for them. But even then, my experiences with this, I use it every single day. One of the best pieces of advice I ever got was a partner over at Torrey's. He told me, John, you go up there for a presentation, know what's the one best trick you ever do? You clench. You clench. And then all of a sudden, you got perfect posture, you're zoned in, and then bam, you're there. Just little stuff like that, like it's stuff that you remember long into the future. And what I think makes it even more exciting is the fact that there is such a lack of mock trial opportunities in Canada. As Jonathan mentioned, in the States, yeah, this thing's huge. The States does have, like they do a lot more litigation in the States. Like it's the USA. People sue people for everything. I'm sure you all have heard about that lady at McDonald's who got a little bit of hot coffee on her hand and sued the company for a couple of $1 million, right? Yeah, like it's America. They like suing people. But that being said, I think in Canada, yeah, there's definitely a lot of potential for this sort of thing to grow. And because there is such a shortage of opportunities right now, students who are able to distinguish themselves through mock trial, who are able to compete with other players on the international stage, with much more developed mock trial programs, these students will stand out far more than if the market here were already filled with mock trial teams. So I do think that this is an incredible opportunity, which frankly speaking, I wish I had access to back in high school. And yeah, hopefully it's something you'll consider. So yeah, again, running through the reasons why you should consider mock trial. It's a chance to distinguish oneself on the international stage. You get to make incredibly valuable connections, not only friends, but you also meet a lot of lawyers, a lot of judges, connections which could yield benefits far into the future. You develop work skills, and importantly, in a very practical sort of context. Get to strengthen your university law school applications down the line, if that is something you're interested in. And yeah, the big obvious one, if you are interested in a career in law, this is a great opportunity to explore it. I'll say, like most exposure I actually had to law back in high school was like grade 10 civics class, which, yeah, frankly speaking, like didn't teach me anything. It was like, this is why voting is important. And like, okay, cool. How does voting actually fit into the system? So yeah, I think this does offer a great opportunity. If someone is even remotely interested in considering a career in law, might as well give it a try before they commit the 4 years and the $100,000 tuition to actually go into law school. And yeah, that's pretty much it. So a few of the questions you might have. So is mock trial only for those seeking a career in law? If you've been paying attention, yeah, you know the answer. Absolutely not. The skills developed here are absolutely transferable into other fields. So even for someone who has no interest in actually practicing the law, like myself, I still do mooting every single year. And by the way, like in law school, mooting, they like doing mock trial, they'll give you credits for it. So for me to like continuously do mock trial means I can take less law courses, which means I'm taking like less other types of courses by doing this, and yet I do it year after year after year after year, because frankly I think learning this sort of practical skill is actually more important than learning the sort of abstract theorems that I would get in other courses. So yeah, not interested in law. I'll be honest. Okay, I'm interested in it. I don't want to practice it. Still, I keep doing it year after year after year. And yeah, you can apply it in business, you can apply it in politics, you can apply it in any field requiring persuasion or advocacy. Okay, another one is how much knowledge do you actually need to participate? And this is one of the things we discussed earlier. There is a general worry that people at the high school level just don't have the sort of understanding of the law to actually be able to do this meaningfully. Pardon my use of language, I think that's hogwash. I don't think that's true at all. In law schools, they'll actually host mock trials, literally the first month of school. These are law students who've literally had like a month of classes at most. So yeah, these are students who have at most learned a month of law. And they're put into the ring, they're put before actual lawyers and judges, they're competing. And these students don't necessarily have a background in law. I didn't cover this earlier, but in undergrad, I was actually a science student. And I worked as a scientific researcher for a while. Going into law school, I knew literally nothing about the law. I spent 4 years of my life filling my head with chemical formulas and stuff like that. And all of a sudden, within my first month, they were putting me inside a court, arguing with people. So no, you don't need a lot of background experience in law. It does certainly help, but it's the sort of thing where you can break it down, and it is possible to get people to be actively practicing very quickly. And yeah, last but not least, how much time commitment is necessary? Now, this is a tough one. I understand a lot of people are very busy with high school and other extracurriculars and other sort of things. As Jonathan has mentioned, yes, indeed, it is very time intensive. So our plan is to host a 2-hour session a week, 2-hour class once a week. There will be 2 of these classes, yeah. But students are expected to spend anywhere from 3 to 10 hours a week working on their cases. Now, the 3 to 10 hours, yeah, it's quite a broad range. In the beginning, it's probably going to be a little bit lighter, as students are mostly just like reading through, the law and understanding and learning those materials. But as we get closer and closer to the competition, yeah, the time is probably going to start ramping up. In the few days leading up to the competition, yeah, it's probably going to be expected that students, ideally speaking, will meet up every single day to run through arguments with each other, to practice with each other. These are very serious competitions, and there's going to be a very high level of competition, and we want to make sure that we're at the level when it happens. So yeah, that brings us to an end of the presentation. Thank you all so much for listening. If you have any questions, we'll take them now.
Just before that, just want to say something before taking your questions. As John and Jonathan both mentioned that you guys can see how less competitiveness of the Canadian mock trial team is, right? If you look at the last year's Empire New York the World Cup competition, out of the top 20 teams, 17 of them are U.S. teams, right? There's only 3 non-U.S. teams, one from Canada, which is Johnson's team, and then another one from British, and another one from Korea. Out of the top 15 best lawyers, 14 of them are from U.S. And there's only one from internationally, which is Jonathan, right? He was placed the 7th best lawyer. So we are here and we want to seriously create a contender, right? We want to create a contender. Same as what we did for debate, right? We have been able to put together a pretty competitive team in debate. right? So we have the last year national champion sitting over there, Grace. He's the champion, in Canada, right? So we have been able to do that for debate. I think we will be able to do that for mock trial as well, right? That's something I wanna just mention, that we want to create a content, right? We're not just creating a interesting club, right? I mean interest club, right? Just for you to having fun here, right? But we want to create something that is going to go out and really to compete on the international stage, and we want to win. If you guys are interested, we're gonna have a sign-up sheet, just preliminary. You can sign up. We have some law professionals here, Masha. She told me before the seminar started, and then they wanna sign up right away. So we'll try to do this. Just collect a bit of information in terms of how many people will be interested. We are looking at Saturday and Sunday. Could be around Saturday noontime or Sunday afternoon. We'll let you know the actual class time once it becomes available. All right. So now I'm going to open up for some questions. Any questions for either John or Jonathan? Just feel free to bring them up. Actually, I do have a question for Jonathan. You have been a competitive debater, right? Can you share a bit of your experience in terms of the differences you think between mock trial and debate?
Yeah, sure. So I think that there's definitely a difference. I think John illustrated it pretty well. Mock trial is much more rigid in the sense that you need to tie all of your argumentation back to particular burdens of proof or particular statures or subsections within the law. So it's much more rigid in that sense. You can't go off making wacky arguments like you might be able to get away with in debate. That being said, I think lots of the skills are transferable. So what you learn about speaking with confidence in debate obviously can be transferred to the mock trial, and also lots of the stuff you learn about rhetoric is also very convincing when it comes to presenting opening and closing statements in mock trial. Some of the actual examinations, so when you're actually asking people questions, whether that's direct or cross-examination, those are skills that you'll probably have to build up from a relatively starting foundation, just because there's nothing really like it in debate besides, you might get a couple of questions within your speech, but the format of actually trying to get out a point solely through questions and not through any sort of statement that you as a lawyer can input is a skill that's pretty new, and you definitely have to relearn if you were a debater. Yeah.
And I should add, there's also a visual component as well. That's not usually seen in debate. Debate is, purely oral. You're essentially, making a case through words alone. Whereas, in mock trial there is, exhibits and demonstrations, and you have to, use your oral skills mixed with your, ability to present visual guides together in order to create a compelling narrative.
Mm-hmm. Yeah. I guess two more things. One, so just on the visual stuff, you'll have exhibits. So you'll have like sometimes Empire will bring in like a bloody it's not an actual bloody megaphone, but they'll bring in like a megaphone that you can use as evidence, and you have to find ways to enter it through different witnesses. So there's technical, legal stuff like that. And then second of all, when it comes to so when it comes to the oral argument part of mock trial, there's also written submissions. So there's competitions, it's not Empire, but there's other competitions that I've participated in where you first have to do a written submission of a factum. So it's essentially a legal argument before they actually select people to present oral argumentations off of those factums is what they're called. Yeah.
So, any questions?
So during practicing, you said that your role plays, either a lawyer or witness. You have no prosecutor or a judge or other roles?
No, you're generally not put into a judge role. That's usually saved for the judges.
Okay.
Yeah, and we should clarify, like the prosecutor is also like a role you're going to be playing, yeah.
Okay.
So it'll either be prosecution or defense lawyer, one or the other.
So when I'm going to interactive because you will use this argument with prosecutor or lawyer and like I'm argument you discuss on just one way. You only speak by yourself.
It's
you. Yeah, if you want to
Yeah, I
clarify,
can give. Yeah, I'll clarify. Yeah, we probably should have made this a bit clearer. So there's two sides. There's the prosecutor, there's the prosecution, and then there's the defense. Typically, we're going to be. It's mostly criminal, so it's the prosecution and the defense. So the prosecution is obviously trying to prosecute the defendant, and the defense is trying to defend the defendant. So, and then for both sides, there's lawyers. And then for both sides, there's also witnesses that you can play. So there'll be prosecution witnesses and there'll be defense witnesses. So the way the trial normally works is that prosecution will give their case first. So they'll deliver an opening statement, and then they'll bring up their witnesses. After they bring up their witnesses, defense obviously has a chance to cross-examine, so ask questions to try and poke holes in what the witness says. And then the prosecution rests, so the prosecution can't bring up any more witnesses. And then it's the defense's turn, so the defense will bring up their own witnesses, and then the prosecution will have a chance to cross-examine the defense witnesses, and then there'll be closing statements at the end. This is how it'll work.
Yeah. Any other questions?
Which area typically is involved?
Generally, the cases are criminal. That's generally the more exciting sort of stuff. I mean, I dealt with one in my first year that was like it was like a woman who tried to, a woman and her husband who had like a suicide pact. They said they were going to kill themselves because they lost their jobs and they couldn't feed their kids, and they were also like going to poison the kids and stuff. And this is based off like a real case, yeah. Yeah, and the question was like, it turns out one of them like backed out at the last minute while the other one did it, right? And then they were trying to charge the survivor, the woman. They're trying to charge her with assisting in the murder of someone because she's the one who went out and bought a bunch of poison. So yeah, usually it's criminal cases, which are quite exciting. That being said, like there can be a diversity. Like I myself, my main area of expertise is intellectual property. So patents, copyright, trademarks. So I do a lot of arguing in terms of that. And when it comes down to that, it's less about murder and more about, hey, you stole my idea, or you stole my artwork, or you stole my invention, something like that. Yeah. So yeah, they can cover pretty much anything in law, assuming it's the sort of stuff that actually goes to trial. Yeah.
So in the actual practice, so because without the lawyer, without the judge, so basically each side will let the other side run through the whole argument because you cannot say objection and you cannot say sustain, right? So is that the way it works? So how about the other side run off a line too much and you want to stop it? Is there part of the practice or this is something
yeah, that'll be part
more?
of, yeah. So like yeah, having the sort of proper decorum and understanding the sort of protocols will be a part of the practice.
Okay.
Yeah, it'll be as close to the real thing as possible. I mean, if they don't get used to keeping within those rules in practice, there's no way you're going to be able to do it before an actual panel of judges.
I see. But
Yeah.
at the end of the day, when both sides present their argument, and what's the criteria to judge which side is won the argument when we said that's it?
So there's a number of things that you do end up judging. The first one is really, do they actually know their stuff?
Okay.
It's pretty clear if you watch one of these mock trials. If someone has actually done their proper research,
Right.
if they actually know what the law is and what it actually means, and if they read all the cases and examine the evidence and try to apply the cases to the evidence in a meaningful way. So yeah, that's a big part of it. And then the other part of it really is, how was their actual presentation, right? Were they actually like a good speaker, or did they seem nervous? One of the big things that I myself got really fixed through this mock trial thing is, I used to say every once in a while when I talk. A lot of people do. It's a fairly common thing. My coaches drilled me so hard on that. They're saying, get it out of your vocabulary. You don't use You say when you're trying to think, just think. And they drilled me and they drilled me and they drilled me, and every single time I went, they're like, no, stop it. And nowadays I don't really do it anymore. Or if I do, it's a lot more rare. So yeah, presentation is another big element of it. But the big question as to who wins is really who pulled together a compelling narrative. Who actually sold you on their version of what happened and how you should deal with it. At the end of the day, as a judge, both sides are trying to convince you to believe them over the other person. So it's really about, did they answer all the questions you had before the trial? So when you go and you got a bunch of questions, you're thinking it's like, oh, I don't know about this, I don't know about that. Did they answer all the questions you have? Did they make you go, wow, you know what? All my questions are answered and I really believe this person? Or did they make you go, I'm kind of convinced, but there's still a few things I'm left wondering about. So yeah, some element of it is really, yeah, how much preparation did they actually do? Because it's pretty obvious when someone just doesn't know the law and they're spewing something that's just not true. There is an important element in terms of, yes, you need to argue something in a persuasive way, but most importantly is really how do you tie it all together? Yeah.
One thing I want to add to that, so just addressing your point about decorum, in practices what will typically happen is that the most senior person on the team will be the presiding judge. So they'll be the ones handling objections from both sides. This way you actually practice decorum in practices, and you don't get drilled on it when you actually go to compete. So yeah, so in our club, we'll have one of the executives preside as the judge for our practice, or when we're lucky enough, we'll have a parent lawyer volunteer come and they'll be the presiding justice. Yeah.
So the way this is planned to actually go down in practice is students will be divided into 3 teams at the beginning of the class. 1, 2, and 3. Essentially, on any given class, 2 of the teams will be acting as the lawyers, arguing against each other, while the 3rd team will play the part of the judge. And in the beginning, yeah, there will be a little bit of a learning curve as they figure all this stuff out. But as time goes on, they'll hopefully become experts. And then by the end of it, they'll know it pretty much as well as any judge out there. So at the end of the day, yeah, like it does give everyone a good opportunity, every class to either practice their oral presentations or to observe someone else and then critically analyze and then apply what they know about the law from the judge's perspective. Yeah.
So how many students usually required to be in a team? How many students?
It's 7, I believe, for Empire.
Yeah, 7.
7.
So there's a bit of flexibility. I think it's like 5 to 7. So you can have less people, but then each person has to take on more stuff.
Okay.
Or you can have less people and, you can have more people and each person takes on less stuff.
Okay. So you mean 7 students which will be represented like both defense and
Yeah. So the way it'll work is that
there is 7. Okay.
the way it'll work is that you'll have 3 witnesses.
Yeah.
So three people on your team playing witnesses, and then 4 people playing attorneys. And then those 4 attorneys will split up the different sort of tasks that you have to do. So 3 cross-examinations, 3 direct examinations, a pre-trial argument, and then 2 statements, so closing and opening. Yeah.
Yep. Any more questions? No? Okay. So if you are, interested of, asking them specific questions individually, you are always welcome just to stay a bit behind. Let me introduce you another important person. Here's Stanley. Stanley, he won the champion for the OBA a few years ago, right? He graduated from Bayview Secondary, Richmond Hill, sorry, Richmond Hill High School, right? Hopefully he will join us soon. So as I mentioned to you that we're trying to put together a team that help us to build a contender here, okay? We're gonna have some sign up sheet outside on the front desk. Just on your way out, if you are interested in joining us, just sign on the sheet. And once again, thank you so much for coming. I mean, the weather is not that great today. Also, we have some handouts for you. You can grab one on your way out. Okay? Thank you, everyone.
Oh, and if anyone has any questions they want to ask me directly, yeah, feel free to come up. I'll be around.